2 medical cannabis initiatives on the ballot for voters in November. I am also a mom to a child who has epilepsy, and that is what brought me to this fight several years ago and continues to motivate me, in addition to the thousands upon thousands of Nebraskans who need medical cannabis as a treatment option. So what I'm going to do is I'm going to start by explaining how the ballot qualification works. We have 2 statutory petitions that are circulating right now. Each of those statutory petitions has a threshold requirement of 87,000 approximate valid signatures that are needed to get those certified to be on the ballot. In addition to the overall signature threshold, there is also a county qualification requirement set forth by the state, which means that in addition to the overall signatures, we need to qualify at least 38 of the 93 counties, gathering 5% or more of the voters in those counties. And this county qualification requirement set forth by the state is really impacting our ability to qualify ballot initiatives in our state. It is a burdensome, unconstitutional requirement that's why the timing of this lawsuit is right now. We are on our way to gathering signatures, but because of this unconstitutional requirement of gathering signatures in at least 38 of the 93 counties, unfortunately the one person, one voice is diluted because of this issue.
Good afternoon, everyone. My name is Daniel-Gutman. I'm a contract attorney with the ACLU and one of the lawyers for the plaintiffs in this case, along with Mindy Rush-Chipman, who's here, and Jane Sue, who's here. Today we have filed a federal civil rights lawsuit in the federal district court for the District of Nebraska. And we are challenging a provision of the state constitution which requires ballot sponsors and supporters to collect 5% of registered voter signatures from 38 of Nebraska's 93 counties. The fundamental problem with this structure is that it dilutes certain people's signatures and votes and provides power to certain counties over others. Let me give you an example. The name of the game in this, and being a petition sponsor, is qualifying counties. And to qualify Douglas County, you have to have approximately 18,000 signatures from registered voters. Compare that to Nebraska's smallest county, Arthur County, you have to have 17 signatures. So what that does when you look at the math is it shows that certain counties have the power to either qualify an initiative for the ballot or disqualify an initiative for the ballot over other counties. And we believe that that's a violation of equal protection. It's a disparity that needs to be justified, and we don't think that the state can justify it. It also violates the plaintiffs, in this case crista-eggers and NMM's First Amendment rights. I'll give you an example. The average volunteer in Douglas or Lancaster County in a 4-hour shift can collect 400 signatures. They can get their voice out and the message out to a large group of people. That same volunteer also volunteering for 4 hours in a less densely populated area collects on average 50 signatures. What this law does is it prevents people from getting their message out in violation of the First Amendment. I do want to make one thing clear. This is not an urban versus rural divide. There are a lot of states that have struck down the exact same requirement that Nebraska has. Numerous federal and state courts have struck this requirement down as unconstitutional. And what they've said is that there's other alternatives that exist. If the goal is to get rural input, you can create a mechanism, for example, on federal congressional districts, which are all evenly populated. You can do it in a way that is even, that does not give one group of voters more power than another. So what we are doing today is we're asking the court to invalidate the multi-county signature distribution requirement for the upcoming 2020